Dental Practice Risk Management through Regulatory Compliance, Part 6. Texas State Board of Dental Examiners Rule 108.9, Understanding and Avoiding a Complaint for Dishonorable Conduct. Hi, my name is Boyd Shepard. I am a clinical associate professor in the Department of General Practice and Dental Public Health at the UT Health School of Dentistry here in Houston. I receive no financial benefits that would create a conflict of interest or restrict my independent judgment with regard to the content of this presentation. At any time while viewing this video streaming course, you can take a break by simply pausing your computer. At the completion of this section, you will be asked to take a short exam in order to complete the requirements for streaming video courses. At the time, you will be receiving instructions regarding taking the exam. Dental Practice Risk Management through Regulatory Compliance, Part 6, Texas State Board of Dental Examiners Rule 108.9, Understanding and Avoiding a Complaint for Dishonorable Conduct. This online course is designed for dental practitioners to gain a greater understanding of the Dental Practice Act in Texas and the rules and regulations of the Texas State Board of Dental Examiners, specifically Board Rule 108.9, Dishonorable Conduct, so that they may implement the appropriate changes and systems in their day-to-day practice that ensures regulatory compliance with these rules and laws. Through understanding and implementation, the participant will also be managing the risks inherent in modern dental practice. Upon the completion of this course, the participant will review, understand, and be able to apply the relevant provisions of the Texas Dental Practice Act and the TSBDE rules and regulations. Be able to apply Board Rule 108.9, Dishonorable Conduct, the focus of this presentation. Value ethical and legal approaches to clinical dentistry in your own practice. And review and implement the risk management procedures and protocols that will prevent patient complaints to the Texas State Board of Dental Examiners. Okay, let's get started. Dental Practice Risk Management through Regulatory Compliance, Part 6, TSBDE Rule 108.9, Understanding and Avoiding a Complaint for Dishonorable Conduct. Prior to diving into the rule, let's get the big picture of the primary functions of the State Board of Dental Examiners. Number one, the State Board of Dental Examiners performs the licensing of dentists and dental hygienists in Texas. Number two, the State Board of Dental Examiners performs the annual registration of all Texas dentists, hygienists, and labs. And number three, the State Board of Dental Examiners in Texas enforces the Texas laws regulating the practice of dentistry. For the best and maximum performance in your office for managing your risks, it is important to be able to locate and utilize the law that regulates your license. Therefore, it's important to know where in the world do you find the rules. In other words, where do you find the Dental Practice Act and the board rules that regulate your license. To find the law that regulates your license as a dentist, dental hygienist, or dental lab in Texas, you simply have to do an online search with any search engine utilizing Texas Dental Board or any combination of those words, and you should get the State Board of Dental Examiners as the first site linked in that search. You'll be taken via that link to the State Board of Dental Examiners website, and on that website you'll find a top bar menu which clearly has the links for the laws and rules for Texas dentists, hygienists, and laboratories. On that website for the State Board of Dental Examiners, you will be able to locate and utilize the Dental Practice Act in Texas, the Texas Administrative Code, specifically the State Board of Dental Examiner rules. Also, you'll be able to see and utilize the board policy statements, the best example of which is their policy statement with regard to the use of Botox. Also, the board has done a great job in answering some frequently asked questions pertaining to the law and procedures of the State Board of Dental Examiners. And you will be able to utilize forms that the State Board of Dental Examiners either recommends or mandates use of in the practice of dentistry in Texas. All of this is important information. It's information that affects your license on a daily basis, and therefore good risk management includes knowing how to access this information. You should caution that new rules are always being proposed without notice to you. Therefore, it is prudent to check the State Board of Dental Examiners website and check it often. You should bookmark that website as a favorite in your web browser for easy access. You should educate your staff on how to access the State Board of Dental Examiners website. Another mode of gathering this information is by subscribing to the State Board of Dental Examiners newsletter at this email address, newsletter@tsbde.texas.gov. The State Board of Dental Examiners routinely sends out emails with current information of work they are doing with respect to new and proposed new rules. Again, on the State Board of Dental Examiners website, you'll be able to find recently proposed rules, as well as rules that have been adopted and that are new to the law that regulates your license. All of this can be located again by simply searching Texas Dental Board. Once you have located the Laws and Regulations tab on the main bar, you can drop down to not only find the recent rule adoptions, but the State Board of Dental Examiner rules, which will take you to the page where the rules are, and there's a similar link under Laws and Rules for the Dental Practice Act as well. The rules are available to you online via a large PDF file, an Acrobat PDF that you can keep on your computer, but it is also available online as separate pages for each rule that's much easier to navigate. Both of those formats are available via these two links on this particular page. Once you click the link for the Texas State Board of Dental Examiner rules, you'll be taken to this page, which is a table of contents for all of the chapters within the Texas Administrative Code under the part with respect to the State Board of Dental Examiners. And this is all of the chapters for the State Board of Dental Examiners that are part of the regulation of your dental license. We will be focusing specifically on Chapter 108, Professional Conduct. Within Chapter 108, Professional Conduct of the Part 5 State Board of Dental Examiners section of the Texas Administrative Code, we will be looking at Subchapter A, Professional Responsibility. For today's presentation, in this video, we will be looking specifically at Rule 108.9, Dishonorable Conduct. This is the entire rule, but the purpose of this slide is not for you to read the rule, but just to show you a broad view, to show you how the rule appears online on the State Board website. In the following slides, we will review the rule section by section in detail. Rule 108.9, Dishonorable Conduct. The dishonorable conduct section is intended to protect the public from dangerous, unethical, and illegal conduct of licensees. The purpose of this section is to identify unprofessional or dishonorable behaviors of a licensee which the board believes are likely to pose a threat to the public. Actual injury to a patient need not be established for a licensee to be in violation of this section. Behavior constituting dishonorable conduct includes, but is not limited to. As a comment to this first part, or this opening or preamble to Rule 108.9, the board has taken the time and effort to discuss what the board's intent is in formulating and enforcing this rule. It's intended to protect the public from dangerous, unethical, and illegal conduct of licensees. So the board is letting you know that their job, as part of what their mandate is to protect the public. They are not in the business of, nor are they mandated to protect dentists. They enforce the law on behalf of the state of Texas against dentists with the sole purpose of protecting the public. Rule 108.9 drills down on that quest and that purpose and that mandate of the state board and lets you know that this section is intended to protect the public from dangerous, unethical, and illegal conduct of licensees. So with the power and the authority of this Rule 108.9, the board is giving the green light to work to identify unprofessional or dishonorable behaviors of a licensee which the board believes are likely to pose a threat to the public. So it's within the board's view, in their opinion, in their perspective, what they believe is conduct that is likely to pose a threat to the public. It goes on to say that actual injury to a patient need not be established. Obviously, if the board is working to protect the public, they should not have to wait for the public or a patient to be harmed or injured, but rather any conduct that the board believes is likely to pose a threat will be enough to trigger and violate this rule. And then following this opening, at the last sentence, behavior constituting dishonorable conduct includes but is not limited to criminal conduct. Number 1, including but not limited to a conviction of a misdemeanor involving fraud or a felony under federal law or the law of any state as outlined in Chapter 101 of this title. So this subpart 1 of 108.9 says that if there is a conviction of a misdemeanor involving fraud or a felony under federal or the law of any state. So let's break that down. A misdemeanor involving fraud is not all misdemeanors. In other words, you could have a conviction of a misdemeanor on your criminal record, but it won't necessarily be considered dishonorable conduct. It would be considered dishonorable conduct if that misdemeanor involved some sort of fraud. Hopefully, Texas dentists aren't involved in getting in any criminal conduct amounting to misdemeanors, and particularly misdemeanors involving fraud, which would be, for example, like theft or obviously fraud itself. As for felony under federal law or the law of any state, the federal law is the U.S. law, and the law of any state would obviously include the state of Texas. It references Chapter 101, specifically Rule 101.8, deals with persons with criminal backgrounds. The purpose of 101.8 is to establish guidelines and criteria for disciplinary actions to be taken by the board against applicants, licensees, or registrants with criminal backgrounds. And so I would refer you to this Rule 101.8 to follow up on what the law and guidelines and criteria for disciplinary actions are for licensees, applicants, or registrants with criminal backgrounds. This rule is not the subject of this video, so we'll go on with the next part of Rule 108.9. The main point here is that dishonorable conduct includes criminal conduct that includes but is not limited to a misdemeanor involving fraud or a felony under federal law or the law of any state. Now, the language that says including but not limited to a conviction may open the door for other types of misdemeanors, which the board will take on a case-by-case basis. And this is where you need to remember, know, and understand that under the preamble, it's all about what the board believes is likely to pose a threat to the public. And that's why, beginning with this Section 1, the including but not limited to language is broad language that allows them to go beyond what they've described here. Subpart 2, deception or misrepresentation. A licensee engages in deception or misrepresentation in soliciting or obtaining patronage or in obtaining a fee. Basically, the question is whether or not the dentist or licensee or anyone subject to the rules of the state board under their jurisdiction has engaged in deception by soliciting or obtaining patronage in a way that is basically a scam, or in obtaining a fee in a way that is basically a scam. In your advertising, and there are advertising rules in the State Board of Dental Examiners rules that deal directly with advertising, and that also in the Dental Practice Act that prevents false or misleading statements, which again uses the word misrepresentation as part of its description. This rule is basically saying that if you engage in any type of misrepresentation, particularly with respect to soliciting or obtaining patronage, otherwise known as marketing, or in obtaining a fee in any way, that not only will you be violative of the rules perhaps with respect to advertising and marketing, but you will also be in violation of this Rule 108.9, dishonorable conduct. And that's another point to be made with respect to 108.9, dishonorable conduct. This is an example of where a licensee, a dentist, can be in violation of some other rule, in this example, an advertising rule, but also doubling up, piling on, you could also be in violation of the dishonorable conduct section that is just broad enough to encapsulate that as well. Subpart 3, fraud in obtaining a license. It is dishonorable conduct if a licensee obtains a license by fraud or misrepresentation or participates in a conspiracy to procure a license, registration, or certification for an unqualified person. An example of this might be going back to the first section of this rule. If a person has some sort of criminal background prior to registering or applying or obtaining a license in the state of Texas, and they do not disclose that information to the State Board of Dental Examiners in their application for their license, and then they are able to get that license, and then later it's found out that they did not disclose all of the information and it was pertinent to answering the questions as part of that application, then they may be in violation of this subsection, obtaining a license by fraud, which is considered dishonorable conduct. I've seen that case a handful of times over the years where that's exactly what happened. License applicant purposely and with intent did not disclose something that clearly would have been identified if they had followed the application and what it required with respect to information of prior criminal cases in the cases that I'm referring to, which were in other states. Either disciplinary actions and or criminal conduct in other states were not disclosed, and later the board found that this information existed and the doctor at a minimum was violated under Rule 108.9, dishonorable conduct. Subpart 4, misconduct involving drugs or alcohol. It is considered dishonorable conduct if the actions or conduct of a licensee include, but are not limited to, providing dental services to a patient while the licensee is impaired through the use of drugs, narcotics, or alcohol. Subpart B, addicted to or habitually intemperate in the use of alcoholic beverages or drugs. Subpart C, improperly obtained, possessed, or used habit-forming drugs or narcotics, including self-prescription of drugs. Subpart D, grossly overprescribes, dispenses, or administers narcotic drugs, dangerous drugs, or controlled substances. Subpart E, prescribes, dispenses, or administers narcotic drugs, dangerous drugs, or controlled substances to or for a person who is not his or her dental patient. Or F, prescribes, dispenses, or administers narcotic drugs, dangerous drugs, or controlled substances to a person for a non-dental purpose, whether or not the person is a dental patient. So there's a lot here in subpart 4 of 108.9. In 4A, providing dental services to a patient while the licensee is impaired through the use of drugs, narcotics, or alcohol. This is basically describing a situation that might be or look like a dentist working in their practice, operating in the operatory on a patient and performing a procedure while impaired either by drugs, narcotics specifically, or alcohol. I've seen these cases. I've seen cases where doctors showed up in the morning having had alcohol basically for breakfast. I've seen it where doctors have come to the office after lunch having participated in the use of narcotics or alcohol over the lunch hour, and so on. In each instance, the dentist is putting the patient clearly at risk, and it's just a matter of time until the patient or the doctor's staff reports that doctor to the State Board of Dental Examiners. Again, the State Board of Dental Examiners does not have to prove that the licensee is in fact impaired, but if there is some risk of them being impaired is all that's required under this rule in the opinion of the board. Subpart B, addicted to or habitually intemperate in the use of alcoholic beverages or drugs. Again, there's no requirement that the board prove addiction. And the second subpart where it says habitually intemperate is a much easier bar or level to meet with respect to this subpart. And all the board has to show in this allegation, if a doctor is alleged to be habitually intemperate in the use of alcoholic beverages, what the board tries to show in this instance when they make this allegation is that there's more than one occurrence over a period of time that's an unreasonable pace or rate of the consumption of alcohol during a particular period of time. Now, it might be that a doctor, and I've seen this case, obtained an arrest for alleged DWI, and the cases were pending as far as the criminal courts were concerned, and there was no conviction, but the person was stopped 3 times over a 9-month period for an allegation of driving while intoxicated. But none of those cases had come to a final judgment in the county or district court in question. But the state board, once they become aware of these arrests, may violate a doctor under 108.9 dishonorable conduct for habitually intemperate use of alcoholic beverages, even though there's been no final state local conviction for DWI. They're merely showing that within a 9-month period, 3 arrests are unreasonable, and in the board's opinion, that is considered habitually intemperate in the use of alcoholic beverages. Subpart 4C, improperly obtained, possessed, or used habit-forming drugs or narcotics, including self-prescription of drugs. What I typically have seen over the years has been the self-prescription problem, usually reported by a pharmacist because they notice an unusual amount of self-prescription or prescription to the same person that may be a family member coming out of one office, and all of it's happening in an unusual, unreasonable amount of time. And typically when you see this self-prescription, it almost always involves habit-forming drugs or narcotics. Improper obtaining or possessing or using is you cannot self-prescribe drugs for yourself, period. And so the improperly obtaining or possessing or using is going to typically be because the doctor is prescribing these drugs through another individual, usually a family member, but sometimes it might be a staff member or someone that is enabling that doctor, and that is how they are self-prescribing these drugs, is prescribing for someone else who then picks up the prescription and brings it to the doctor. Subpart 4D, grossly overprescribes, dispenses, or administers narcotic drugs, dangerous drugs, or controlled substances. Obviously, it can be considered dishonorable conduct if it is found by the board or if the board believes that the prescription writing that is being performed by a doctor is grossly unreasonable and is a gross overprescription for these types of drugs, and I believe dovetails with the improper obtaining and using of habit-forming drugs in subpart 4C, that it's another way of capturing this type of improper conduct. Subpart 4E prescribes, dispenses, or administers narcotic drugs, dangerous drugs, or controlled substances to or for a person who is not his or her dental patient. Again, this could be a situation where a dentist is prescribing for, let's say, a family member who is not a patient of the practice, who probably lives in a different city and needs some type of pain medication. It is improper and it is dishonorable conduct that if you're not the dentist of record for a particular person, you should not be prescribing any type of medication for a person, whether or not they're a family member or close friend, whatever the case may be. There is no exception and there is no excuse. The law is clear that you can only prescribe for people and persons who are your patients and not anyone outside of your patient base. And finally, subpart 4F, that when you do prescribe any type of medication, it has to be for a dental purpose. And it does not matter whether or not the person is a dental patient. In other words, even if it is a dental patient, anything that you prescribe must be for a dental purpose. There must be something about the patient's dental treatment history that reconciles the prescription of the drugs, and that must be for a dental purpose. (108.9) subpart 5. Assisting another in engaging in the unauthorized practice of dentistry or dental hygiene. It is unlawful and it is considered dishonorable conduct for a licensee that holds a dental license and employs, permits, or has employed or permitted a person not licensed to practice dentistry in an office of the dentist that is under the dentist's control or management. In this situation, what I have seen over the years is where dentists have basically set up and enabled non-licensed persons to hold themselves out and work and perform and deliver dental services clearly defined as the practice of dentistry. And so the State Board Rule 108.9 considers any engagement for the unauthorized practice of dentistry or dental hygiene to be dishonorable conduct. The person who's engaging in the practice of dentistry without a license will be guilty of a third-degree felony in the county where this conduct occurs. The dentist who engages in that unauthorized practice of dentistry by assisting that person will be found violative of this 108.9 dishonorable conduct. Subpart 6, failure to comply with applicable rules, laws, regulations, and orders or remedial plans. It is unlawful and considered dishonorable conduct when a dentist violates or refuses to comply with a law relating to the regulation of dentists, dental hygienists, or dental assistants. It is unlawful and it is considered dishonorable conduct if a dentist fails to cooperate with the board investigation, and it is unlawful and it is dishonorable conduct if a licensed dentist fails to comply with the terms of a board order or a remedial plan. As you can see, this particular rule, 108.9 subpart 6, is subdivided into 3 parts. The first part being violating or refusing to comply with the law relating to the regulation of dentists, dental hygienists, or dental assistants. So by default, when you violate some other rule of the board, for example, Rule 108.7, by failing to obtain informed consent, then you are by default automatically also violation of 108.9 dishonorable conduct because you have violated a law relating to the regulation of dentists. So this is what I call a pile-on doubling up rule, because you've already violated Rule 108.7 by failing to obtain informed consent, and in doing so and being violation of that rule, you've automatically violated 108.9 subpart 6 by violating and not complying with a law relating to the regulation of dentists. The second part of this subpart 6 says, fails to cooperate with a board investigation. Going back to our example, if you don't have informed consent as part of your dental record, some dentists might be incentivized or think that it's okay to not cooperate with the board investigation by not providing all of the dental records pertaining to a particular case or a patient, which isn't a very smart thing to do because the board is entitled to all of the records upon demand, and that's under Rule 108.8. And so when you fail to turn over all of the records in a board investigation or otherwise comply with all of their legal and reasonable requests, you could very well also be in violation of 108.9 by failing to cooperate with the investigation. It may turn out that if you did cooperate fully with the board investigation, the board will find everything that it needs and that you are in fact not in violation of any other rule. So it makes no sense to not cooperate with a board investigation, because you could be clear of any other alleged violations, but you may in fact find yourself in violation of the dishonorable conduct rule if you did not cooperate with the investigation in the first place. Finally, the third part of the rule fails to comply with the terms of a board order or remedial plan. A board investigation proceeds by starting with a patient complaint or otherwise an alleged violation of the rules. The board does an investigation, and after a series of administrative steps, including perhaps an informal settlement conference and or a hearing before the State Office of Administrative Hearings, and then finally a final full board vote to accept a proposed board order, whether by agreement or otherwise, a licensee will be issued a board order or a remedial plan to address the violations and allegations that the board has concluded have been violated. There will be terms set out in those board orders and remedial plans that spell out the compliance requirements to bring the doctor back in compliance with the state board, basically the sanction and disciplinary action for the alleged violations, whatever they may have been. Going back to our example of failure to obtaining informed consent might result in a board order or a remedial plan that requires the doctor to take a risk management course, not unlike this video presentation, particularly the video with respect to Rules 108.7 and or Rule 108.8. And so after so many hours of taking remedial continuing education and perhaps paying a fine, you would then be in compliance of the board order. But let's say that you paid the fine, but you never do get the CE, you never do get the hours of CE that are required under a board order or remedial plan, then you would be found in violation of 108.9 dishonorable conduct by failing to comply with the terms of a board order or remedial plan. Rule 108.9 dishonorable conduct, subpart 7, inability to practice safely. It is unlawful and it is considered dishonorable conduct if a doctor is physically or mentally incapable of practicing in a manner that is safe for the person's dental patient. Now, over the last 20 years, I've never seen a situation, thankfully, where a doctor was found to be mentally incapable of practicing in a manner that is safe for the person's dental patients. I've never seen a situation where someone was mentally disabled or otherwise incapable of treating patients. I'm not saying that it has never happened, I've just never seen it personally. However, in 20 years I have seen 2 or 3 situations where a doctor was in fact physically incapable of practicing in a manner that was safe for the person's dental patients. Now, one instance had to do with someone who was on a particular type of medication that caused that doctor to basically have the shakes or jitters, and they were not able to steady a handpiece, and it was just not smart, and it was not common sense that the doctor should not treat patients when they couldn't control their nervous system, and they would attempt to do dental work even though their hands were clearly shaking as a result of the medication that they had to be on. Clearly, this was an inability to practice safely and clearly a violation of the 108.9 Dishonorable Conduct rule. I've also seen it in instances of doctors who were physically incapable of practicing either because they were dealing with pain or other types of nervous system situations in other parts of their body that made it wholly unsafe for them to treat their patients. Doctors who are dealing with any type of physical or mental impairment need to not only get the help they need medically or psychologically or otherwise, but obviously need to not pose a threat or any type of harm to their patients. Rule 108.9, subpart 8. Discipline of a licensee by another state board. It is unlawful and it is considered dishonorable conduct if a dentist holds a license or certificate to practice dentistry or dental hygiene in another state, and the examining board of that state either reprimands the person, suspends or revokes the person's license or certificate, or places the person on probation, or imposes another restriction on the person's practice. So, if a licensee in the state of Texas is also a licensee by holding a license or certificate in another state or jurisdiction, then if they are reprimanded in the other state, or if their license is suspended or revoked in another state, or if the other state imposes another restriction on their practice, then that is considered a violation of Rule 108.9, dishonorable conduct. It does not necessarily mean in any of these instances, in any of these subparts, that a dentist found in violation of 108.9 will then be ordered to stop practicing dentistry in Texas. It only means that you will be considered in violation of this rule, and the board, through a board order, will advise the licensee of what needs to be done to rectify or otherwise comply with remedial work as a result of these violations. In your registration, annual registration, there are questions that ask licensees in the state of Texas whether or not they hold a license in another jurisdiction, and if so, has any of these things occurred? Reprimand, suspension, revocation, or any other type of restriction on a person's practice. Obviously, you have to answer those questions truthfully, as you may not only be in violation of this rule by not disclosing that information can be in violation of other parts of this rule and other rules, which could lead, in fact, to suspension or revocation of your license. Rule 108.9, Dishonorable Conduct, Subpart 9, failure to comply with Medicaid, insurance, or other regulatory laws. It is unlawful and it is considered dishonorable conduct for a Texas licensed dentist to knowingly provide or agree to provide dental care in a manner that violates a federal or state law that regulates a plan to provide, arrange for, pay for, or reimburse any part of the cost of dental care or services, or regulates the business of insurance. Basically, it's dishonorable conduct for a Texas dental licensee to engage in any sort of insurance fraud, whether it's Medicaid or any other type of insurance or any regulatory laws that regulates the business of insurance. If you're committing any type of act that's fraudulent in the areas of dental insurance or the business of insurance generally, then that is considered dishonorable conduct in violation of Rule 108.9. Rule 108.9, Subpart 10, Improper Delegation. It is considered unlawful and it is dishonorable conduct for a Texas dental licensee to improperly delegate any task to any individual who is not permitted to perform the task by law, this chapter, or practice restrictions imposed by board order. Chapters 114 and Chapter 115 of the State Board Rules deals with the delegation of duties to hygienists and dental assistants. In those rules or chapters 114 and 115, you will find very, very specific language which addresses what task can be properly delegated to dental hygienists and dental assistants. Obviously, if you violate rules under chapters 114 or 115 of the State Board Rules, in all likelihood, you are doing some sort of improper delegation. So not only have you violated any of the rules in those chapters, but you have also by default automatically violated this Rule 108.9 Subpart 10 improper delegation. You'll be in violation of whatever the improper delegation was specifically in those rules in those chapters, and then doubling up and piling on, you will also be in violation of dishonorable conduct. Therefore, for risk management, it is wise to understand the rules with respect to the delegation of duties to both hygienists and dental assistants, covered in another section of the rules. Rule 108.9, subsection 11, unprofessional conduct. It is unlawful and considered dishonorable conduct if a Texas dental licensee engages in conduct that has become established through professional experience as likely to disgrace, degrade, or bring discredit upon the licensee or the dental profession. This particular subpart of Rule 108.9 is very broadly written. It basically captures all of the conduct enumerated in the first 10 subsections of the rule, but in case anything was not covered in the first 10 subsections of the rule, this subsection 11 of 108.9 captures anything that the board believes might be considered conduct that is likely to disgrace, degrade, or bring discredit upon the licensee or the dental profession. Remembering from the opening and the preamble that the belief as to whether or not the conduct is likely to disgrace, degrade, or bring discredit upon the licensee or the dental profession is not in the opinion of any particular person or the licensee themselves or even a patient, but is squarely in the opinion of the board. It is the board's opinion, it is the board's belief, it is their discretion and authority to allege whether or not they believe, whether or not the board believes that there has been unprofessional conduct, conduct that is likely to disgrace, degrade, or bring discredit upon the licensee or the dental profession. And it is in this sense that you can obviously see that this particular subpart is all-encompassing and very broadly written. So, if you have any questions with regard to this video and any of the information presented in herein, feel free to send an email to utsdcontinuinged@uth.tmc.edu. It is a broadly written and very detailed rule with respect to the number of issues covered. And I also recommend that you go back and review not only this rule, but other rules that it references and any other rules that may be included, that if you violate one, you violate this one as well, as discussed in the presentation. This has been Dental Practice Risk Management through Regulatory Compliance Part 6. Rule 108.9, Understanding and Avoiding a Complaint for Dishonorable Conduct. The course references include the Dental Practice Act and the State Board of Dental Examiners rules and regulations found on the Texas State Board of Dental Examiners website at this URL. This completes Dental Practice Risk Management through Regulatory Compliance Part 6. Rule 108.9, Understanding and Avoiding Complaint for Dishonorable Conduct. It is time for you to take a short exam in order to complete the requirements for streaming video courses. Due to the nature of our subject content, a passing score of 90% is necessary in order for you to pass the course. Upon a successful completion of this exam, you will be visually informed that you have met the requirements to proceed. If you fail to answer enough questions correctly, you will be instructed to take the exam and a new set of questions will be provided. You will have 3 chances to fulfill the requirements. If you are not successful, you will be instructed to review this section again. Good luck on the exam. If you're ready to take Dental Practice Risk Management through Regulatory Compliance Part 7, TSBDE Rule 108.2, Understanding and Implementing Fair Dealing, upon the completion of this exam, you will be provided a link to continue. If you wish to proceed at a later date, you will need to log in, and no further payment is necessary since this is a continuum.